Well, thank you. Good evening and welcome to everyone, and I mean everyone, because I believe there are over 2,000 people out there somewhere in the UK and all over the world who are joining us, and I think it's absolutely wonderful. It's a shame that we can't see you all, and we can't, but the brilliance of technology is that it facilitates so many people being able to participate in this special event without the need to travel from the comfort of their own homes, if that's where they are. So I'm Hazel Genn. I'm a former Dean of the UCL Laws faculty, and I'm currently UCL Vice-Provost International and Advancement. I've had the privilege of working with Baroness Hale over a number of years in different contexts, and it's a huge honour for me this evening to be hosting Baroness Hale, This Is Your Life. Lady Hale has graciously agreed to allow us to hear directly from her about her career trajectory, her path to stardom, or spiderdom, as I sometimes think of it, and to talk about some of the highlights of her tenure as the most senior judge in the United Kingdom. But at a time when, as a society, we've become acutely aware of the unequal impact of the pandemic on different social groups, highlighting enduring structural inequalities in our society, I think it would be good to use some of this opportunity to ask Lady Hale to reflect on the contribution of the judiciary to the aspiration for more equal societies, the challenge of achieving greater equality of opportunity, of achieving greater diversity within the justice system, and also the constitutional role of the Supreme Court. Now, many of you have submitted some excellent questions in writing in advance of this, and we've selected several that I'm going to include in my conversation with Lady Hale. And when I'm asking a question that has come from the audience, I will indicate that. Because there are so many people signed up, we can't do a live Q&A. It would be unmanageable. I don't think the technology could handle it. And so that's why I've decided to incorporate your really very, very interesting questions into the conversation. I don't want to take up too much time in introduction because you want to hear from Lady Hale, not me, but just a few words of background to our conversation. Lady Hale is an exceptional person who's blazed a trail as an outstanding judge and as a role model for women. An academic who became the youngest and first ever woman to be appointed to the Law Commission, the first woman ever to have been appointed to the Judicial Committee of the House of Lords, the first woman deputy president of the UK Supreme Court, and then most recently, the first woman president of the UK Supreme Court, the most senior judge of the United Kingdom. This is a remarkable series of firsts, and Lady Hale's global appeal is reflected in the extraordinary number of people who've signed up to join this event, and we're thrilled that you're all here. Lady Hale's career path has been steep and somewhat unusual for a president of the Supreme Court. She was born in 1945 in Leeds, the daughter of 2 head teachers and one of 3 sisters. At the age of 3, the family moved to Richmond in North Yorkshire, and Lady Hale was educated at Richmond High School for Girls, where she and her 2 sisters were all head girls. Quite something. She later studied at Girton College, Cambridge, the first from her school to attend Cambridge, where she read law. Lady Hale was one of only 6 women in a class that had 110 men. Just imagine that. She graduated with a starred first, and guess what? She graduated top of her class in 1966. So very many firsts, Brenda. After graduation, she was appointed as a law lecturer at Manchester University, specialising in social welfare and family law. 3 years later, she was called to the bar by Gray's Inn by self-study. So she became a barrister by self-study, and yet again, coming top of her year. I think we're beginning to see a bit of a pattern emerging here. Working part-time as a family law barrister, she spent 18 years, mostly in academia, becoming Professor of Law at Manchester in 1986. In 1984, she was appointed to the Law Commission, and over a period of 9 years, she oversaw a number of important reforms in family law. On leaving the Law Commission, she was appointed a High Court judge in the Family Division and was then rapidly promoted to the Court of Appeal in 1999, the second only woman on the Court of Appeal. She became the first ever woman law lord in 2004, transferring to the Supreme Court when it was established in 2009. She was appointed Deputy President in 2013 and then served as President of the UK Supreme Court from 2017 to 2020. Now that would be a stellar trajectory for a man, but for a woman at that time was quite extraordinary. And as I was looking over this before, I noticed that I was using the words exceptional and extraordinary very often. But I have to say, Lady Hale, that your career, as I read it again, I think that your career path has really been quite exceptional and extraordinary. Lady Hale has achieved national and international celebrity in many ways. But one of the things that characterizes her skill as a judge, certainly in my view, is the sheer brilliance and clarity of her expression. Her ability to explain complex legal concepts in a way that can be understood by ordinary people is, here's his word again, exceptional. And this was never more important than in the global spectacle of delivering the court's unanimous decision in the royal prerogative Brexit case in 2009, streamed live, which deemed the suspension of Parliament to be unlawful. I received an enormous number of emails then of people who were not lawyers and who were just interested, saying what was amazing about that was the way in which Lady Hale was able to explain what were rather obscure concepts to the ordinary person in a way that was comprehensible, so that they could understand the decision, understand why the decision had been reached, and understand the importance of it. And that is a real skill, and it is not one that all judges share. We will perhaps return to that case at some time later on, but since this is your life conversation with Lady Hale, what I'd like to do is to start the conversation with the first steps on your path to the Supreme Court. You probably didn't see it as a path at that point to the Supreme Court. I've said a bit about your early life and education, but can you say something about your ambitions at school? I mean, can you say that at the age of 5 or 6, you knew you wanted to be a judge or be in the Supreme Court? What were the driving forces? You know, what led you on your path?
Well, thank you for that quite exceptional introduction, Hazel. It doesn't feel like me at all. I didn't, of course, set out to be a judge. But what woman would? The first full-time woman judge was appointed in 1965 when I was 20. So the idea that at school I would have wanted to be a judge would just have been ridiculous. Nobody in my family had anything to do with the law. But of course, I did set out with a very firm and clear ambition to go to university. I came from a family of teachers, as you've mentioned, and it was their ambition for all 3 of their daughters, if they wanted to go to university. And this was at a time when I think it was roughly 5% of the population in the relevant age group went to university, but twice as high a proportion as boys as girls. So it wasn't necessarily any more realistic an ambition than becoming a judge, but it was the one that I had. And all 3 of us made it successfully to university and through university. So it wasn't really unrealistic.
And why law?
Now, my flippant answer to that is that the headmistress of the small girls' grammar school, which I went to, was a historian. And my best subject, I thought, was history. But she did not think that I was a natural historian. So she said, what else might you do? And we started looking about. In other words, as I say, my head teacher did not think I was clever enough to read history. She was keen on my doing economics, and I didn't fancy that at all. Far too much theory. I'm not really a theoretician. And I thought, well, what about law? So my second reason for doing law was that I had become fascinated with the British Constitution as part of my school studies, and particularly the struggles of the 17th century, the century of rebellion, restoration, revolution. which established the main features of our modern constitution. Such a romantic story, such an exciting story. And I think that's what propelled me in that direction. And then the third reason, I expect, is that I wanted to avoid becoming a teacher.
You can see
in fact, I think all three sisters tried hard to avoid becoming teachers, but we all, one way or another, ended up in the education profession.
Can I ask you, something that strikes me is when you started to study law, were you immediately fascinated by it? Did it almost surprise you at just how interesting it was?
I'm not sure that it surprised me, but I was immediately fascinated by it. Absolutely. I mean, we did do constitutional history and we did the history of the English legal system. So, you know, we were doing subjects that I liked. And we did Roman law, of course, and I had done Latin A-level and I liked Latin. So that was also good. The only proper law that we did was criminal law, which in those days was comparatively simple. And I enjoyed that. What I loved about the law, and still love about the law, is the way that you study it by trying to solve problems. This was a new way. You know, at school, you write essays, essay after essay, as for languages and for history. But in the law, you're presented with a fictional set of facts, and you're asked to advise the parties or one of the parties, in other words, to solve the problem. And I loved that, and I still love it.
As we can see by the clarity of your decisions. Can I just ask you quickly, did you encounter any barriers? Well, I suppose what I'm interested in is whether you had any particular mentors that helped you along this path, and whether you encountered any barriers at that early stage. I mean, I think that people often have things that help them and some things that hold them a bit back during their career. Can you think of anything in particular?
Yeah, well, I think the mentor was our headmistress, whom a lot of people didn't like. You know, she was a rather stern and apparently conventional woman, but she wasn't as conventional as you might think. She had all sorts of interesting ideas. So she was definitely a mentor. There were other teachers at school as well. I think we were very lucky. Small school, in a beautiful place. So a lot of dedicated teachers who stayed. My parents, obviously, were a huge encouragement. But unfortunately, my father died very suddenly when I was 13. And that might be seen as a setback. But in fact, it probably made me and my younger sister, who was 12 at the time, all the more determined to become independent and have our own profession and be able to look after ourselves, because we had experienced the sudden deprivation of the main breadwinner in the family, although my mother also worked in the school where he was a head teacher, and the uncertainty and insecurity that I think we all felt for a few months after that. And then my mother, who was a woman of great courage and determination, dusted off her teaching qualifications and got herself a job, which was a very fine indication of the necessity to get yourself qualifications and have a career. So I think what might have been a setback was also an encouragement.
I think it's
make the most of myself.
It's interesting that something that someone could have said had a devastating blow and actually had really hampered their ability, provided some impetus for you to be determined to be independent. That is actually very interesting. I'm also interested in the impact of teachers. I think that sometimes people don't recognize the extent to which a particular teacher, either at school or university or somewhere, can have a powerful influence on people's decisions and also on their confidence. And I sometimes think, I don't know if you think this is true, but I sometimes think that women need or women benefit greatly from having mentors who are supportive and who push them on.
Yes, well, we didn't call them mentors in those days.
No, but someone who played that mentor role.
It's a very modern sort of concept, isn't it?
Yes.
But yes, everybody, when they are at school, needs somebody who can see something in them and try and bring that out. And obviously, I was an academic girl in an academic school. But if I'd been a non-academic girl in an academic school, one would hope that somebody would find something that I was good enough at to encourage me to develop and make the most of myself. That's what we all need out of our education.
What one would hope for. Okay, moving on a little bit now. You went from academia, you did a bit of part-time practice, you went to the Law Commission and then to the Judiciary. So you've had a kind of range of experience. You haven't stayed on one particular career path. From your experience, what advice would you give to women seeking to reach the pinnacle of a legal career or any profession from your experience?
Well, I don't know whether I ever set out to reach the pinnacle. I don't think that I did. What I set out to do was to reach the next rung up the ladder from the one that I was on, which seemed, on the whole, a realistic ambition. And what I tried to do was to work hard, to be the best I could at what it was that I was doing. And what I always say to students is, try and enjoy what you're doing, because if you enjoy it, you will work hard at it. And if you work hard at it, you will be much more likely to succeed at it than if you don't. So the worst thing is to be doing something that you really don't enjoy. And I've been so lucky to enjoy everything that I have done. Well, not everything, obviously, but all the various occupations that I have had. So that's what I would generally say. And the other thing that I say is, if something interesting comes along, even if it wasn't in the game plan, seize the opportunity, go for it, do it.
Yeah.
And I think that's actually the best, because it's amazing how many opportunities do trot along if you're open to them. And that happened to me throughout my academic career. Everything that I did as an academic lawyer to get my academic show on the road, because as you know, Hazel, any academic needs to get their show on the road, don't they? They have to establish their own academic enterprise. But everything that I did led one way or another to a public appointment.
That actually really resonates. That really resonates with me, because people often say, you know, how did you plan these things? And I often say, I didn't actually plan it. You know, things came up and I thought, oh, that sounds nice. I think I might try and do that. And then the other thing that you said, which I absolutely agree with 1000%, is that you just, whatever it is that you do, try and do it as well as you can, to work hard at it and to do it as well as you can. And I think that that's, you know, that we can all, everybody can do that. Just try and do their very best at something, to try and be good at it. Moving on a bit to thinking about equal rights, equalities, inequalities. You've served as a judge in the Family Division, you've been on the Court of Appeal, President, Deputy President, and President of the Supreme Court. That means that you've dealt with a very wide range of cases involving equal rights, entitlements, and opportunities in all sorts of different circumstances. Standing back a little bit, could you say something about what you think the role of the judiciary is in the promotion of equality or in reducing inequalities? I mean, I know obviously that, you know, government policy is important, but what's the specific role of the judiciary there in helping to achieve some degree of, or a bit less inequality?
Well, as you know, judges decide cases. They can only decide the cases that come before them. So that's a limitation on what judges can do. You know, we can't set out like a politician can, you know, waving a banner saying, this is what I want to achieve. But there are two things that judges can do. One of them is a formal role that we have, which is to apply the equality legislation. And since the 1970s, we have had an ever developing series of laws against discrimination. And so we can seek to apply those. And then since 2000, we've had the Human Rights Act, and there's an anti-discrimination provision in the European Convention on Human Rights. So we've got some formal equality-seeking powers. But the other thing, of course, is to be aware of the social and economic context in which any legal problem arises. So if you're dealing, for example, with, to take an obvious example, the enforceability of prenuptial contracts. Now, prenuptial contracts are obviously designed to give one party to a marriage less than that party would otherwise be entitled to. So we've got an inequality there already. And there's also usually an inequality of bargaining power and other inequalities to do with personal characteristics. So to my mind, you have to be aware of those inequalities when you are assessing either what the law should be, or at an earlier stage when you're assessing what the facts were. These are things that we have to try and be aware of. And I think that's one of the things that my previous experience, both as an academic lawyer, where I did many more subjects than just family law, it wasn't my only subject by any means, and at the Law Commission, where again, I did many subjects other than family law, one becomes aware of the wider context of what one's doing, both as an academic and as a law reformer. And so as a judge, it is a good idea to try and be aware of the wider context of what you are doing, which is what I've always tried to do.
I might come back to that on the question of diversity and how having that different perspective may have an influence on decision making. But at this point, I thought I might put in a question that we had from the audience in advance, or a couple that relate to the question of equalities and inequalities. And one of the questions asked is, what key change in the way we live our lives do you believe is necessary in order for us to see a noticeable shift in attitudes towards women in a multicultural society?
That is an excellent question. And if I knew the answer to that, I would rule the world. But of course, I don't. What I would like to contribute is that we need more and more young men to want to lead different lives from the ones that men have been traditionally assigned. Because the pressure on men is to be the high achieving, the workaholic, the breadwinner. It's quite difficult for them to decide that they're going to organize their work-life balance a little bit differently. Women, on the other hand, now tend to want to have it all, but you can't have it all to the same extent because there are only 24 hours in the day. So trying to balance a family life, a home life, an outside work life, it might not be a family life, it might be something else, and a work life, and do it all brilliantly is just too much to ask of anybody. So I think that trying to get a greater equality in the distribution of the various ways of leading one's life between the sexes would make a big contribution. I don't want to say too much about the multicultural aspects of this, because clearly equality between the sexes varies very much according to the cultural context in which we're talking. Yesterday, I was taking part in a conference run from Israel, from Bar-Ilan University in Israel, about religious feminism. And of course, this was mainly about the problem of the conflict or perceived conflict between feminism, the belief that women are the equal of men and should be treated as such, with some of the tenets of the main Abrahamic faiths. So I'm aware that that is a difficulty. I still think that a commitment to a more equal distribution of roles and work between the sexes is the way forward for everybody, but I appreciate that it's much harder in certain cultures than it is in the one in which I was brought up.
I certainly don't disagree with that at all, but getting that change requires some major shifts in thinking, you know, among men, but also among employers of men, and not just among employers of women. And this actually leads very neatly to another very good question and very relevant question, which came from the audience in advance. This is something that I feel keenly, is do you believe the lockdowns, which have, as a result of the pandemic, which have many working from home, will have any long-term effect on women's careers? Now, this is related to law. I think that it isn't just limited to law, but you've been asked, will it have any long-term effect on women's career in law? And if so, would these be likely to be positive or negative?
Well, who can say? It seems to me that there are some good things and some very not good things. If you think of somebody who is trying to run a practice from home, I know more about barristers and the problems that they have. Zoom is a fantastic thing, but it's really hard to keep concentration over a screen over a long period. And yet people are having to go to court hearings remotely and coping with trying to keep all the balls in the air in a very different environment from what they're used to. It's difficult for everybody, the clients included. And so that must be exhausting. And if at the same time you have your children at home and you have to find ways of distracting them and hopefully improving their minds as well, then that's a really difficult set of circumstances. Of course, if both parents are at home, well, then one hopes that they would be sharing that out in an equitable way. Who knows? It goes back to my answer to the first question, basically. I've heard stories of people who are, and I've heard stories of people who aren't.
Yes, and I've seen some data that suggests that that the burdens are not necessarily equally shared. And I think that one of the things that lockdown has done is to highlight working from home highlights all kinds of differences, not just between women and men in childcare, but also differences between those who have caring responsibilities, either of children or others. Yes. If you have caring responsibilities, it does make a big difference.
It does.
I'm not going to say it's all negative, but
no, well, that sounds negative, but I think there are some positive things, because I think that the courts have been able to work out ways of being more efficient and doing some things remotely, which could perfectly well be done remotely. I mean, I don't myself think that witness actions where facts have to be found ought to be done remotely. I think they should be done face to face if humanly possible. But there are all sorts of routine legal tasks which could perfectly well go online. And a lot of the business has been shifted online more quickly than it otherwise would be. And that seems to me to be a positive thing, not necessarily for women, but for everybody.
I think there are some positives. I think there are also some downsides, but that's another conversation we can have about remote courts, which is an extremely interesting topic. Moving on then, and again, it flows a bit from the discussion we were having before, to think a bit about diversity in the judiciary. Now, this is something that you have felt quite strongly about for obvious reasons for a long time. You've spoken frequently about the need for greater diversity within the judiciary. And I know that you've articulated this on many occasions, but just again, why is it so important? Is it because women decide differently from men? Or is it to do with the optics of the justice system? Is it to do, did having women decide, did having you and then another woman on the Supreme Court make a difference, did any noticeable difference?
Well, all of those, basically. There are lots of good reasons for wanting greater diversity on the bench. Number one, as I always say, is that the law and the courts should be there for everyone, and everyone should be able to feel that they're their courts, that it isn't a small group of elite white men who are laying down the law for the rest of society. We used to think that, but I think we've got away from that. Mm-hmm. So the more the courts can reflect society, the better that is. Of course, they've got to be good lawyers and they've got to be principled people and so on. They've got to have the necessary ingredients to become a judge. But with that baseline, clearly, that's number one reason. Number two reason is optics, because I regard the first reason as democratic legitimacy. The optics, as you mention it, is how things look is increasingly important. Mm. You know, the values of the justice system are justice, getting the right result, fairness, getting the right result after a fair procedure, and equality, treating everybody equally, which doesn't necessarily mean treating them the same, incidentally. But, and if the bench is demonstrably not treating everybody equally because of how it looks, well, then that seems to me to be unfortunate. You know, absence is important. Then there's equality of opportunity, because we know how many young women are starting out as lawyers and have been doing for decades now. And yet there is still an attrition rate, which means that they are not yet equally represented at the highest echelons of the profession. Now, some of that is a systemic problem with the legal profession. Some of it's to do with the methods of appointing judges, about which, Hazel, you know more than I do. But equality of opportunity is another reason. So it's only when we get to the fourth reason that we get to, and maybe the decisions would be improved as a result. Not all decisions, not always, but going back to what I was saying earlier about the need to try and appreciate the context in which decisions are being made, the greater diversity of perspectives on that context, the better the decision is likely to be. And there's quite a lot of evidence from other walks of life that where collective decisions have to be made, they are better if there is a diversity of thinking and background and experience around the room. You know, there's some grit.
I agree, and it isn't just the difference between it, and it isn't as simple as, well, women have a different life experience and therefore they're going to decide things differently. I think the point that you make, and it's really important to stress, is that it's diversity of background, be you female or male, because I think that you need a range of backgrounds among men as well as a range of backgrounds among women. You need people from a range of perspectives, particularly when you're sitting as panels.
Yes, yes, and even if you're sitting on your own, your presence in the court and amongst the other judges can be important. You know, if you're there, when I was a trial judge, we did used to have lunch together. I'm not sure that happens so much these days, but which is a shame and wrong. But if you're a woman there around the lunch table and casually sexist or racist comments can be made, which does happen, you can call it out or just make people feel uncomfortable. And that's a good thing. I'm sure many women judges will have had the experience of having sat around the table and had people make remarks that they felt should not be made, or at least should be called out, and probably left it a little while before they began to do it, and then began to do it.
Do you think there are any, I'm not going to ask you to name cases, but can you remember cases where you think that you have come at it because of your different experience, different life experience, or different preoccupations, whatever, that your approach has actually made a very real difference to the way the decision might have gone, and so has had a very direct impact on the outcome of a case?
Yes. Oh yes, I can think of quite a few, many of them in areas where you would expect that it might make a difference. So I would have to think very hard to think of one in a different area where you might not expect that it would make a difference. But certainly, obviously, in the wrongful conception cases, I'm fairly sure that one way or another, my approach to those cases made a difference. The Montgomery case about informed consent to medical treatment. Now, the main judgment was done by two of my male colleagues, and it's a brilliant judgment. But getting over that, the problem in that case, which was about injuries to catastrophic injuries to a baby at birth, caused by the fact that the mother was an insulin-dependent diabetic, and had a large baby, but she was a small woman. And there is then always a risk of something called shoulder dystocia, which is just, even to mention it makes one's blood run cold, actually, because the baby's shoulders get stuck, and it's a major obstetric emergency. There was a tendency amongst some of my colleagues to focus on the risks to the child, which actually, although they materialized in this case, were not huge. But of course, the risks to the mother are horrendous. And that didn't seem to be something that had loomed large in the thinking of some of my colleagues. So I think that did make a difference. And there are other examples as well, but those are the two that come most strongly to mind.
Something that actually flows again from this, and is a question that was submitted in advance from the audience. Given your interest in increasing diversity in the judiciary, what's your opinion on the potential use of positive discrimination, as well as the setting of quotas for underrepresented societal groups during the process of judicial appointments?
Well, I have always said that I am not in favour of positive discrimination, in the sense that you appoint a less well qualified woman or member of a less advantaged group instead of a better qualified one. I think that is, for a start, not good business. You do want the best qualified people to do the job, and also it's wrong towards the better qualified person, but it's also wrong towards the less well qualified person. It's a separate question, of course, about how we judge who's the best qualified. That is a much trickier and more difficult question, and one which I think we need to do a lot more work on. But that's why I'm not in favour of positive discrimination. And that means that quotas, which are a form of positive discrimination, don't seem to me to be a good thing. But I do think targets are a good thing. I think counting is a good thing. We didn't used to count. Publishing various sorts of
years ago.
Yeah. Publishing statistics about diversity in the judiciary, watching trends, seeing how things are going. So I do think there's quite a lot that can be done and is being done to improve matters without going over to positive discrimination, as I say.
I certainly think that targeting keeps people's minds focused, doesn't it?
Yeah. Yes, it does.
But I think there's a whole other very large area relating to how we assess merit, which again is another conversation we could have on another day.
Well, it is a large area, but I would rather attack that, and also some of the underlying assumptions about who gets which sort of judging job, which are very, very deep rooted and hard to attack, and that's what I think we ought to be going for.
Do you want to say anything more about that at this point, or just raise?
I just raise it as
an issue. Okay, yes, I won't push you on that. Now, we've had another question, which I think I'm going to read in full because I want to do it justice. Another question from the audience that starts, Lady Hale, you're an inspiration to so many young female lawyers and have championed women's rights throughout your career. How can we ensure the space for women in the judiciary is not limited to white, middle-class, able-bodied, cisgendered, heterosexual women? And this person says, I'm a firm believer that feminism should fight the fight of all women, and I fear that women falling within minority groups are being disregarded and not properly reflected in the judiciary. How can we recognise our privilege and use it to fight for the space that our sisters deserve? That's a long question, but there's quite an important issue in there.
That's a very important question, and there is a view which I have heard amongst the BAME community who are looking to improve the ethnic diversity of the judiciary, that all the focus on the women has distracted from the equally important focus on ethnic minorities. And I have sympathy for that. So I think the answer is that we have to look at diversity along loads of vectors and try and champion different sorts of diversity, which will include intersectional diversity, which is what you're talking about. And that if we fight on that broad front, well, then it will, of course, involve bringing up some men who might not have been brought up otherwise, but it will be to the benefit of all women as well. So that's the way I would look at that.
Fine, thank you. I want to move on now to your tenure as President of the Supreme Court, because that is just such, I'm not going to use the word exceptional again, but it was amazing, wonderful. I mean, the cries of joy when you were appointed President of the Supreme Court for so many different reasons was just wonderful to behold. And so I want to ask you, on taking on that role, you'd had a little bit of time as Deputy President, but on taking on the role as President, what were your ambitions? I mean, this is a huge job. It's not just being President of the Court of Final Appeal. It's a huge internal role, but also an external role, an outward, global facing role. So what were your ambitions? What might you say were your key achievements? And do you think there was any unfinished business that you left behind?
Difficult, that last one. Being President of the Supreme Court of the United Kingdom is not the huge role that being Lord Chief Justice of England and Wales is. It may be the top of the judging tree, which in a way it is, and it may have an even wider representational role.
I think that's what I meant. It's in terms of its significance, not the kind of weight of daily work, operational work, but it's.
But you're not running the justice system of England and Wales, which the Lord Chief Justice is doing. So I felt it important to make that point, because it really is important for everybody to recognise what a huge, almost undoable job Lord Chief Justice is, whereas President of the Supreme Court is not an undoable job. It's a very enjoyable job, because you are leading a group of, well, you're one of 12 very clever, very hardworking, very individual, different, but very committed people. But they're definitely a diverse bunch intellectually, in the sense, not about intellectual capacity, of course, they've all got that, but in their their views of the law and of the world are very different. And so it's a wonderful job to be trying to lead them. My main ambition was to leave the court in as happy a place as I had found it, because my predecessor, Lord Newburger, had made the court a very happy place where we did all get on remarkably well, despite our differences and despite the fact that we did from time to time disagree with one another publicly in our judgments. But we always tried to do so with a level of courtesy and respect, rather than with the rather more rumbustious style of certain Supreme Courts elsewhere in the world. So that was my main ambition, that internally the court would be as happy a place as I had found it. Externally, one hoped that the court would continue to grow in respect with the rest of the world, the legal world in the United Kingdom and the legal world outside the United Kingdom. And part of that was, of course, that we were much more open and transparent than the law lords in the House of Lords had been. The House of Lords, we were stuck in that committee room on the committee corridor, very hard to get in, very hard to find your way, not televised, not an easy place for anybody who was interested in what we were doing to come and see. Whereas, of course, the Supreme Court proceedings have been broadcast from a very early stage. And that, I think, makes a huge difference. It enables people to see what sort of work we do, how we do it. And having a YouTube channel on which we try and explain our judgments in a way that we hope that everyone can understand, that also is a big step forward. But I can't claim the credit for that. All of those were started.
But it has done fantastically. It's done fantastically well in being open, in being transparent, and I think helping people's understanding of what goes on in that court. So, and this is another question from the audience. I'd like to claim credit for all of these, but these have come from the audience, so I will. What was your favourite moment being, actually these two bits of the question may come together. What was your favourite moment being President of the Supreme Court? And did you have a case that you particularly enjoyed ruling on?
Well, I'm bound to say that the 24th of September 2019. Favourite isn't quite the right word, because that was such a challenging case. But it's probably the moment for which the whole court should feel justly proud of what it achieved on that occasion, I think.
And did you enjoy giving the? I mean, enjoy might not be the right word, but that moment. I mean, I can still remember very, very clearly that moment where you delivered the decision.
I think enjoy is not the right word, and in fact, pride is probably not the right word. But it was an immense source of satisfaction for the court that we had been able to hear the case so quickly and to bring out a judgment so quickly after we had finished the hearing. Obviously, it wouldn't have been much point if we hadn't been able to do it quickly. No. But the Supreme Court doesn't normally do things with quite that speed. So that was something that was a great satisfaction. And the sense of collegiality, cooperation from the justices, of course, but also from the whole of the court staff was a great sense. And it put huge burdens on the court staff to be able to handle things so quickly, and the press of people and all the interest that there was in the case. And a certain amount of worry about security, which we don't normally have. That proved completely unnecessary, but there was some worry. So it was a massive achievement for everybody in the court, and the fact that we were able to get it out so quickly.
I'm sure it involves some frantic writing. Without asking you to reveal any secrets, I thought that one of the outstanding achievements of that was to achieve a unanimous decision, which I think made a very big difference to the impact of the case. Was that, as I say, without necessarily giving away, was that difficult to do? Was that something that took negotiation, or?
Well, there is always, before, during, and after a case, a level of discussion. People are exchanging views, moderating, changing their views in the light of what other people have to say. After all, that's the whole point of decision making, isn't it? You try and absorb the arguments and make the best of them. I don't think it's a secret that I followed a technique which had been used in a previous case by my predecessor, which was to ask everybody to put their views on the 4 issues in the case onto 2 sides of A4 after the first 2 days of argument, because we had 3 days of argument, but the first 2 days we'd heard from all the parties. And we just had interveners, important, but interveners on the 3rd day. And so I asked everybody at 9 o'clock on the morning of the 3rd day to send round a note with their views. And it became pretty clear from that that we were in substantially the same place. And it meant that we could focus on what we really wanted to know about when we heard the parties give their replies. And it meant that the discussion was refining rather than a real ding-dong where people were disagreeing with one another. It was a refining discussion afterwards, which made it a great deal easier then to go away and write it up.
I've heard you mention that before. I think it's a fascinating approach and clearly worked very well. Another question that came from the audience, which I think probably does flow on from this, which is because obviously it was politically hugely controversial. And that's why the eyes of the world, I think the eyes of lots of the world was on it. And the question is, in the absence of a written constitution, is an apolitical Supreme Court a dangerous myth?
That's such an interesting question, isn't it? Because it is normally thought that it is written constitutions that draw the apex court into politically controversial decisions. And of course it does, because the whole point of a written constitution is that you have entrenched provisions which curtail the powers not only of the government, but also of the parliament. And it means that the people with the last word are actually the court, which, and many of the questions, no, not many, some of the questions on which they have to rule are questions of party political controversy. So that is the situation in which courts are generally accused of being political. In fact, it varies very, very much from country to country how political the courts are, because the method of appointing the judges of the apex court has a considerable impact on that, and the political culture. I mean, the United States of America and Canada, for example, there they are inhabiting the same continent, North America, and yet the culture is very different. The method of judicial appointments is different, and they manage, therefore, to be able to decide cases in ways which are, the Canadians, in ways which are just nothing like as overtly political as is often the case in the United States. Now, of course, we don't have a written constitution. That means that the apex court is not at the apex of the constitution. Parliament is at the apex of the Constitution. And if Parliament doesn't like anything that the Supreme Court decides, Parliament can change it. And that must never be forgotten. They can do that. I can only think of one example, obvious example in my career where they did do that. And it was a case about damages for mesothelioma. If you remember that case, Hazel?
I'd love to say that I can immediately remember it, but I'm not sure that I do. But there is another one that I can remember where a decision was overturned almost immediately, actually to do with students' fees, whether they were residents of the United Kingdom. I can't remember.
Oh, that's not in my time.
That's in a long time ago.
A long time ago, yes. Yeah. Anyway, so yes, it can be done. And so although sometimes the questions that we have to decide could be regarded as political because they are matters of party political controversy, not always, or they could be regarded as political because they have to do with the governance of the country. I don't myself think that they are taken for political reasons. And I say that because I can put my hand on my heart and say that with one or two exceptions, I did not know the party politics of my colleagues, either among the law lords or among the Supreme Court justices. Appointments are not made on party political lines. And also, if you looked at the pattern of judgments, you could discern perhaps an attitude to the law and the relationship between the various branches of government. But rarely was anybody as consistent as a strong political allegiance would suggest that they might be, very rarely. So I don't think that it's a myth that we're apolitical. I think that generally speaking, we are apolitical in the sense in which I am using that word. And long may we remain so. I think it's the greatest possible safeguard for the liberties and rights of individual members of society that the court tries to make up its mind according to the law and not according to anything else.
Absolutely. So I presume that you wouldn't be in favour of any greater political involvement in judicial appointments.
Well, I certainly wouldn't be in favour of the sort of politician in charge system that there is in some places. And I wouldn't be in favour of political quotas or anything like that. It's an interesting question. Our appointments used to be in the hands of the Lord Chancellor, basically, and he was a politician.
Yep.
But on the whole, he did not make political appointments, hasn't done since the Second World War, people generally think. Certainly, I mean, I've had however many judicial appointments I have had, half of them were from Conservative Lord Chancellors, and the three most recent were from Labour Lord Chancellors. So, and none of them would know what my politics were. I'm not sure I know myself.
Good.
There we go.
I want to get on to, I've just noticed that I can't believe that time is rushing away so quickly. I want to ask you about your current preoccupations, because once you retire as president of the Supreme Court, it somewhat releases you from the constraints of judicial office, doesn't it? You don't necessarily go wild, but you don't have to be quite so careful in terms of speeches or writing, whatever. So can you tell us, what are your current preoccupations? What are your any specific projects that you're working on, plans, things that you're going to be doing?
Well, of course, I filled a diary for 2020 with numerous conferences, conversations, foreign trips to conferences and things, all of which either disappeared or were postponed, and now they've been postponed twice, or went online. Increasingly, they went online, which was good. I mean, it's not as good as face-to-face, but it is really wonderful that we're all able to be here together. And I think that is half the fun. Yeah, I can sit in my study in North Yorkshire and look out of my window at the snow, but still be talking to you, Hazel. I don't think your background is really your background, but
no,
it's
I'm in
very
the quad at UCL.
exactly.
Really.
You would have a coat on though, I think, if you really were.
I'm in a quite untidy bedroom, which is hidden by the.
Yes. Well, anyway, so it's been interesting, but obviously I like learning. I like interacting with other people. I'm writing a book at the moment, which it's about me, unfortunately, and this is difficult for me because I'm perfectly happy talking about the sorts of things we've been talking about, but to put more of myself into a book is really proving quite a tricky thing to do. It feels so selfish to be doing that, and yet
really?
I think that's what the publishers want, so I'm doing my best.
I think that's probably what the public might want as well, because I think it would be fascinating to read, and so if you can, put your own thoughts into it. Any other particular legal issues, constitutional issues that you're particularly interested in at the moment?
Well, there are many such, and of course, if times were different and I weren't so busy, I am a member of the House of Lords. And I am now entitled to take part in parliamentary business, but I have not done so yet, because that requires a level of engagement with the parliamentary IT, which I have not yet got round to. You have to have your parliamentary machine, and I've only just got hold of that. But also it does require, I'm amazed at how hard they work. I mean, I'm keeping my eye on the daily lists, on what they're doing, the various bills they're discussing, and so on. And I am amazed at what they do. And it would be, I'm sure, something to which I would like to make a contribution in due course, but I think I've got enough on my plate at the moment.
Imagine. Can I ask you? I'm not getting flippant, but I'm getting slightly lighter here. Can I ask you, is there any case that you'd like to reverse? Any case that you've decided, which on reflection you would now like to reverse?
Yes. Now that is very difficult, and I'm not sure. I haven't got a glib answer to that one. There are cases in which I dissented that I wish the majority had agreed with me. There are cases where I was overturned on appeal, and I wish that hadn't happened. But whether there are any cases where I regret what I myself decided, I think is a trickier question. You could bowl me a few candidates and see what I say.
I don't think I will. I think that it's difficult. I mean, I think it's difficult to kind of look back and say I would have decided, and I can't think of any in particular that I would say, would you not do that differently now? But actually, one of the things I am interested in, which is a question that I think somebody asked, which I've always been interested in, and that's writing dissenting judgments. I've always wondered whether there is actually, I mean, one of the fantastic things about our particular system is that we can accommodate dissenting judgments, which recognizes that there are different views, legitimately different views, and the majority wins. But as a judge sitting on a panel, are there pressures against writing a dissenting judgment? Not least that it's going to take you time to do it, rather, if you agree, and then you don't have to write a separate judgment. But are there cases where, or is it that you have to feel that you disagree really strongly before you can justify writing a dissenting judgment?
I think that most people are reluctant to dissent. It would be a shame, wouldn't it, if judges on a collegiate court were anxious to do as much dissenting as possible. I think on the whole, that is not the case. So that if it's not a particularly important case, or if it's not a matter of great principle, people probably don't think that they ought to dissent. One can think of exceptions to all of this, of course. So usually you are dissenting because you have quite firmly taken a different view from that of your colleagues and can write it down. Because, of course, one of the things that happens with writing judgments is that you sometimes think you've got an answer, and then when you try and write it down, you find it doesn't write. And this can happen, that it looks as if the majority, this is particularly so in the Court of Appeal, it looks as if the majority is 2-1 one way. And so somebody is fingered to write the judgment. And then they write the judgment and the majority can flip, or it can go 3-0 or whatever, because the writing makes a difference to the thinking. It's got to write properly. Mm. And so one wouldn't do a dissent unless you could write it properly, I think.
I often find that as an academic, actually, if I find an article, if it's impossible to write an article, I think maybe actually I don't know what I want to say, or maybe what I'm trying to say is not what I actually think. So I have those
That's
kinds
right.
of problems myself.
Yes.
I see that we're coming close to the end of time, but I've got one really nice question that somebody submitted in advance, which I think is very interesting, and I thought about a lot myself, which is, what piece of advice were you given that you did not follow, did not regret, and are probably the better for it?
Well, I was glad to have notice of that question, Hazel, because it required some thought. But I think it was when I was asked by a senior member of the Lord Chancellor's staff whether I would like to become an assistant recorder. This was in the days of the tap on the shoulder. Assistant recorder, baby judge in Crown Courts and County Courts. And at that stage, I had been out of courts for nearly 10 years. So, I'd given up my practice at the bar, and it might even have been 10 years. And so I hadn't been into a courtroom for a long time. And so I go back and ask my professors in the University of Manchester for their advice. And 2 of them said, "Oh, don't do it, Brenda. It will get in the way of your academic career, and do you really think you can do it anyway?" sort of thing. I didn't follow that advice. I said, yes, I'll give it a go. It's part of my philosophy. If something interesting comes along that's going to be a challenge, I'll give it a go, said I. The other 2 professors had also encouraged me to give it a go. So it's not a very good example, but it's the one that I can definitely say I was given quite firm advice by 2 senior people who had power over my career, and I didn't take it. And if I had taken their advice, of course, I would not have had the subsequent career that I had. So I'm very glad I didn't take it.
That sounds like an extremely good decision, both for you and for all the rest of us. And I'm very, very glad that you didn't take that advice. We're going to end in a minute, but I'm just going to ask you one quick personal question. Sorry, I wasn't going to, but I'm going to because I want to. What do you most enjoy doing when you're not working?
Yes. What do I most enjoy doing when I'm not working? Well, I quite like cooking. I enjoy doing jigsaws and other sorts of puzzles of various sorts. And of course, I enjoy reading. And
is that fiction or non-fiction or everything?
Everything, yes. But of course, were we not in lockdown, I would also say I enjoy going out to the theatre, to the opera, to eat. These are all wonderful entertainments that at the moment are denied us. So that's why I have to enjoy the cooking, you see, and the other sorts of entertainment that I wouldn't have had time for if everyday life had been what it has
No.
more usually been.
Actually, I remember seeing you did a TV program once, and one of the scenes I remember from that program, I don't know which one it was of you doing your cooking. It was the first time I realized that you enjoyed cooking so much. But certainly there's plenty of opportunity to do that in lockdown. So I think that probably it's time to bring this to a close. It's been fascinating talking to you, Brenda. It's lovely to hear your reflections on your career and some of the subjects that we've covered. I hope that very, very large audience out there, which sadly we cannot see, has enjoyed it as much as I've enjoyed listening to you. I'm sorry that we couldn't do a live Q&A, but I think it would have just been unmanageable. But I just want to thank you again very much for giving up your time, for being so frank and willing to answer these questions, and wish you well in this next phase of your career. And do finish those memoirs. Is it called memoirs?
Yes, I'll do my best. But I want to thank the audience for the questions that they sent in, because there are some really interesting and unusual ones, and they've made me think, and that's always what I like to do.